Thank you. Fascinating discussion. And while you're coming up with the terminology and the common meanings, maybe ODR is the first thing to define, because there are virtual codes, there are paperless codes, there's ODR, there's ADR. Maybe it's a good place to start. But I start from 1948. In 1948, there was a person called Harla who was caught with opium in the princely state of Jaipur, then the princely state of Jaipur. Apparently, it was illegal. Very petty case, but it soon traveled to the Supreme Court, where it was the facts were that in 1948 there was an illegal possession of opium, which was made illegal in 1938, which was an amendment to a 1924 act of the princely state of Jaipur. And in 1951, which was just a year or so after the constitution was adopted, Justice Vivian Bose, the great Vivian Bose, said, you know what, you can't hold this to be illegal because the amendment was not publicized, it was not published. It's a landmark judgment, Harla versus State of Rajasthan, 1951. I'm not a legal expert, but it's a fascinating thing to read that he replied upon principles of natural justice and English precedents to say, if it is not published by the government, if it is not publicized, then it's not law. We've come a long way from 1951 and those sort of laws. But in 2017, there was a Supreme Court judgment in the case of Provident Fund Act, where they gave a judgment and within a few months they had to rectify it, because it was pointed out that you while making the judgment you have relied upon the wrong version of the act. So whether it is a Harla or whether it is a Supreme Court judge in 2017, access to the current version of the law is vital, right? So this is what we call as the single source for law. Single source for law will be a comprehensive, authentic, up-to-date, reliable source of law. If the law principle, if the judicial principle is you can't rely upon ignorance of law as an excuse to plead not guilty, that is the onus put on the citizen. Even more onerous, if not the same, should be on the state to make that law available and accessible. Now, accessible has many forms. It should be in regional language, it should be explainable for people with disabilities, all those are there. But fundamentally, what the law applies, as it applies to me at a particular point of time, should be made known to me, which is not happening. We believe that there is a need for something which is comprehensive, authentic, updated, and reliable. Comprehensive because it needs to contain all levels of the state. Union, the state, the municipal, which really, if you're in the restaurant business, it's all about municipal laws. It could be regulators, right? All levels. It should be at all points of time, whether it is 1950 or 1990. And then you also have sectoral variations. So it's comprehensive. Then it has to be authentic, which means to say, you should be able to say, this is the law. Somebody has to say it. It has to be reliable, which means to say that there's a difference between authenticity and reliability. Even a private publisher can be reliable. And it has to be up to date. It can't be even 1 week old. Now, this is not a new idea, unfortunately. This idea has been implemented in the form of India Code, a portal that gives you laws. It has failed miserably. You can go take a look at it. You will not visit it again. There is a need to bring in fresh energy into thinking on what the next gen India code should look like. Again, India code is not a new idea. Other jurisdictions, just like the HMCTS and the ICT, other jurisdictions have also suffered this. So you will find
it's the same as the Federal Register in the United States.
Absolutely, right? So the UK possibly is a more robust mechanism, and I'll come to that in just a bit. So UK, US, Australia have all done this, which is to say, when there is a strong federal government and so many regulators, you need to consolidate and make it available at one point of place. Now, there is, of course, economics behind this, which is there is a monopoly given to the state. A law does not become a law unless it is published in the Gazette. Now, it is not that the laws are not published; it is published in the Gazette, but they are so disparate and almost disfigured, because you'll find one amendment here, one schedule here, years apart. So there is a need to break this pattern. So this monopoly power has led obviously to inefficiency. It has also led to a very strong private publisher market. There are some great publishers who fill this need between the inefficiency of the state monopoly and the needs of the citizens and the legal players. Very strong publishers with very good editing teams bring together the law. And in fact, the government relies on these private publishers for their needs. Now, you may say that when there is a flourishing market, where is the market failure to come in? We believe that it is a state duty to do it and not just a function of the market. This is information arbitrage and not a particular value addition. The value addition should come from the legal advice. The single source for law should not be seen to be giving out advice. It is only information. It is not giving you fact-specific situations and guidance. That will be left to the legal fraternity, lawyers, etc. That is their real value addition, and the private publishers should enable these legal fraternity to do those tasks and not just be information aggregators and information deriving value from information arbitrage. Now, what this requires is, one of the important things that we have seen whenever we talk about it with the government circles is, who will do it? How will it be done? Give us some proof of concept, right? The idea seems very attractive. Nobody disputes the idea. It is always, in my discussions, it is the how that is the more engaging discussion. The idea is seductive enough to draw people into it, but it is always the how and the who that makes all the difference. I don't have an answer for who. It has to be the state. Who in the state? Clearly, this needs a massive update of the administrative capacity of the state to engage with technology service providers. But it is not just technology service providers. That leads me to all of these ideas that I am presenting here are from the paper that we have written called the Single Source for Laws, which is a part of the series on the next generation justice platform. As soon as we realized that dispute resolution is becoming digital, the first question we asked was, okay, where are the laws on which you will base these next procedures are? And we didn't find them, and that is what led us to this paper, Single Source for Law, which my colleague Sandhya has authored, and I'm here only just presenting those ideas in the paper. Now, while we talk about this technology aspect of it, it is this question of harmonizing the language. If somebody says form under Companies Act, there are various forms. If somebody says address, there are various types of addresses. So there is a need to evolve a common language on what law terms mean. This is known as ontology, legal ontology. So there is a need for us to derive this legal ontology Because when you start thinking about a single source for law, it is not just a workflow in which you will find the latest version of law. You also need to make it accessible to machines and codes. Of course, this I am only kind of going into now these third or the fourth stages of implementation, because the first two stages are what other countries have already implemented, which is to say a version control of laws of the land. Um, I'm now coming to the stage where that is already in place. I'm trying to further flesh out the imagination of what a good, robust single source for law would be, because otherwise it would be unupdated and not useful after a point of time. You need to derive ontologies that can then be used in making these codes machine readable. Does not mean automation. It does not mean artificial intelligence and lack of human agency. It is in fact a reinforcement of human thinking into the code so that it becomes more human centric. It is like all ontologies, needs to be developed by the community, needs to be open source, and signed off by institutions for it to be acceptable. There also needs to be the second stage of ontology is the knowledge graph, which is to link these concepts as relationships so that there is a hierarchy and there is a sequence. So if you need to have a company ID, first you need to be registered under the registrar of companies. Those relationships need to be drawn and agreed and signed off. Now, the way I see it, this is much like a Google map, right? I mean, or any map. Maybe Map My India is better. You know, it's like mapping the landscape of laws of the land, on top of which services can be built, whether it is a Zomato or a Swiggy or your Ola. A laws of the land landscape mapping can help in building of those solutions. Um, Very recently, the government has made mapping of the land more relaxed. Private players now do it. We think there should be a slight correction in the case of laws. The state needs to step up and make its presence felt, and maybe let the private publishers do the higher end value addition rather than just do information arbitrage. Those are the thoughts that I had, and you can read up about our legal ontology initiative that was launched in May, and our single source of laws paper, which is a couple of years old, on our website, and happy to take any further questions on this.